Good morning, everyone. This is Melissa. She is with White and Bright White and Bright Law. I'm sorry, I should have looked
White
at
and
that.
Bright LLP.
LLP. Okay, I was like, it's not the usual. Okay. And she is actually the attorney for our company. And so we know her, we like her, we trust her, no like trust is all there. So and she's coming on to do some training around the AVID today, but it's more than just the AVID. So there's going to be questions. If you have any questions throughout, just drop them in the chat, and then I'm sure we'll open it up at the end. This is going to be great for you, whether you're a new agent or an experienced agent. So Melissa, the floor is yours. Feel free to go ahead and start and share your screen if you need to and all that good stuff.
Thank you so much. All right, let me get into slide mode here, and then let me share screen. Oh, that is not the screen I want to share. Okay, I am having issues. All right, hold on one second.
I also have your slideshow too, so if it's a little bit easier for me to pull it up, I can do that as well.
Yeah, I am just not the most technically sound person, if that's okay.
No worries. Yeah, let me
Ashley, you're
grab
awesome.
this here. I want to open it in a new slide though. Let's see. All right, let me do this.
All right, guys. Well, she's getting that open real quick. My name's Melissa Engel. I work for White and Bright. We are a law firm here in North County. We've been doing real estate law for over 40 years. We've worked with CAR, helped them draft their forms. We've worked with NAR. We work with all the local associations. I personally deal with representing agents and brokers, whether they're being sued by third parties or if they're dealing with the DRE. I help with DRE accusation defense and compliance. I help brokerages do, compliance audits to make sure they're, legally sound with all the rules and regulations for the DRE. I also do employment law. And then our firm does also do trust and estates. If you ever have a trust, transaction and you need help, that's something we can help with as well. So feel free to call me anytime. I think I've met some of you are new. So hello, nice to meet you all. Today, we're going to go over the top 3 legal issues that get you sued. And like I said, I kind of mentioned a moment ago, all roads are going to lead to the AVID when we talk about this. But if we can scroll down, just scroll down to the very next slide. Yeah, this one, topics covered. Perfect. Thank you, Ashley. So today I'm going to go over the 3 main issues I see as to why agents get sued. The real big one is going to be the non-disclosure of material facts. So we'll spend a lot of time on that. But I wanted to start with lack of communication. And then we're going to also talk about investigation troubleshooting, because a lot of times, and I'm sure you guys have dealt with this, when you're dealing with a transaction, something comes up, what do? A new disclosure, a new discovery. Sometimes that gets fumbled, and that's what ultimately results in the lawsuit. So I want to touch on that today as well. Going on to the next slide. So, and I see this not just for real estate agents and brokers, I would say any professional. The number one thing that gets people in trouble is lack of communication. I hear this a lot from suing parties saying, well, I didn't hear from my agent. I didn't hear from my attorney. I didn't hear from my doctor. If people don't know what's going on, they automatically start suing and they just assume the worst. So I give some examples here. One of the big ones I see a lot is, once the transaction goes into escrow, kind of handing everything off to the transactional coordinator. I've heard in many depositions, parties say, I didn't hear from my real estate agent after we signed the agreement. Stay involved in all aspects. Make sure you are hand-holding, you are explaining things, and you are just there. You are available. That's important for the party to know that you're there, because if something does come up and you haven't been communicating with them, they start to blame you, even though you may have not known a thing about what's going on. So being involved throughout the transaction really helps. Another big one, not explaining documents or disclosures. We've all signed lengthy agreements, whether it's software or signing up for whatever. Most people aren't reading these documents. We all know our clients, they get these car forms, they look at them maybe for a second and they'll probably sign, but they're not reading everything. So I know in the car forms, there's a lot of disclosures. Go talk to an attorney, go get this inspection, consider the soils, the foundation, all this stuff. They're not actually looking at it. So I always tell your agents, you know, unfortunately, you got to go above and beyond, and you got to put stuff in writing to them and really explain, especially when you represent a seller and they have duties to disclose. When you send over those disclosures, I always tell my agents, have a template email in play, explaining here's what your duties are. Here's what you're going to have to disclose. Here's what you need to think about, because you're also covering yourself as well. Not just your client. If there is a lawsuit later, we're going to want to look at all the texts and all the emails, and we want to see what advice was provided. And so those explanation emails suddenly become very vital. I've won and lost cases based upon having those additional emails. And I will tell you guys, the vast majority of agents just rely on the car forms and that's it. And sometimes you can win a case based on that, but not always. It's the agents that go above and beyond and give those additional explanation emails about, here's what to know about disclosures. Here's the things you should be concerned about when you get a home inspection. Those things kind of really matter ultimately when we start talking about who dropped the ball and where. Again, the similar, not advising clients of rights and obligations in writing. I especially relate this to sellers and their duty to disclose. Always put that advice in writing. A lot of times you're going to be meeting with clients at the property, or having phone calls. If you guys discuss important things about their duty to disclose, or a disclosure item that comes up, or a serious question they have where you told them to go get advice of counsel or another professional, follow up with an email confirming that. You want to document all of this in writing. It's very difficult when a lawsuit happens later and everything was done by a phone and there's no evidence of that, because then it becomes a he said, she said situation. And, you know, we don't always know how those will play out. So confirming things in writing is extremely important. And then lastly, another big topic I see where their communication sometimes is lacking is explaining deadlines. You know, the parties get these car purchase agreements and there's so many deadlines in them. They don't understand what they are, what they trigger, why they matter, when they are. So giving the clients kind of a quick outline, okay, here's the key dates. You know, you've got to try to get your home inspection by this date because you're going to be asked to be removing that contingency by this date. You should have your loan in place by this date. It doesn't have to be every single deadline in the agreement, because not all of those are going to apply to your client, but make sure they're aware of the big ones. I've found in my personal practice and with my agents, when I rep them in their practice, the more proactive you get your client involved, meaning you're giving them some ownership over what's happening. Okay, here's the deadlines you need to comply with. Give them things to do and give them a way to interact with the transaction. Then they take more ownership and responsibility over what's happening. Because a lot of times when lawsuits happen, the number one thing I hear from sellers or buyers is, I thought my agent was representing me, was going to do everything. Well, we know that's not true. You guys have a limited role, and we'll get to that later. But you have one lane. Buyers and the sellers have their own responsibilities. And many times, if they're not being engaged in the transaction, they don't really take that to heart. And so getting them engaged by making sure they're aware of deadlines and things like this and having this proactive communication helps. It's not the communication or lack thereof that ultimately results in the lawsuit, but it's one of the biggest side effects that we see as to how we got there and why we are in a lawsuit is simply lack of communication. So I kind of wanted to just go over that a little bit and, you know, kind of sound like mom, I realize, but it's a good reminder to always keep proactive communications. And I always advise, again, do template emails. If you know you're going to be sending out, you know, the typical disclosure email to your sellers, have a template ready. If you know you're going to be sending disclosures to buyers, have a template ready about here's how to review these. If you know they're going to be getting home inspections, have a template email ready where it has all the other inspections you may suggest to them. You can have those things kind of in the back. That way you kind of save time, because I know what I'm talking about is a lot more emails, and that's a lot more work on transactions. And, you know, it's a struggle as it is. You already have enough work to do in a limited amount of time. But if you kind of create those template emails, that will be really helpful. Next slide. The other thing that I want to be clear on communication, one of the biggest missteps I see agents and brokers do is overextending and getting out of their lane. And what I mean by that is taking on responsibility for things you're not responsible for. So I always tell my agents, be clear in writing to your clients what you will and will not do in terms of service, what your role is. Many times, especially first-time buyers, they don't know, they think you're going to go down and pull permits, pull plans for a property, go figure out the tax information for them. And I realize, again, it says all this in the CAR forms that you're not going to do it, but they're not reading those. And so you want to make sure it's very clear that you're not going to do these things, because as we'll talk about a little bit later, if you extend yourself and start to take on these things, you then take on responsibility for the outcome of those things. So be very clear about the things you're not going to do. For example, you're not going to pick the home inspector for them. You're going to give them a list. They're going to pick who they want, things like that. Always advise clients of their duties relating to the transaction in writing. I know I keep harping on it, but really sellers with their disclosures, there are a lot of sellers out there, guys, that don't want to disclose certain things, want to kind of brush over it. It's, probably in 60% of my cases where it becomes clear that a seller knew about something and didn't disclose it to their agent. The way you cover yourself is to give them that explicit instruction in writing, like, hey, you really need to disclose anything that can affect the desirability of the property. And we'll go over that standard again, but it's a really broad standard. They've got to disclose anything that they know. And so if you give that instruction in writing and they still ignore you, that's your defense. So you want to make sure you're doing that additional communication there. Remember, you're not the expert in everything. And even though your client may think you are, you got to make sure that you manage their expectations there. So always advise clients in writing when to seek out inspectors, when they should go get legal advice, second opinions, all of that. Even if you say it on the phone, or in person, make sure you follow up with the confirming email again, because that's going to be your evidence later if anything becomes an issue. And then this is the big one, and we're going to talk about this again at the end. Tell your client what information is not verified and where you received it from. There have been cases in California where individual agents and brokers have passed on information that they say they received from the seller or for the other agent about a property to their client without telling them where they learned this information from and whether or not they went to go determine that it was true. Well, in all those cases, guess what? The information wasn't true. And in those cases, the court found the agent who represented that client to be liable because they should have told them where they received that information from and whether or not they confirmed it was accurate. We'll go over that again, but that is a big standard here in California. So I'll give you a perfect example. Say you're representing a buyer and the seller's agent provides you with some, permits or something, some historical permit information for the property. Pass it on to your client, but you're going to pass it on to your client and say in writing, this is who I received it from. I haven't went down to the city to verify the accuracy of any of these. That's kind of how you want to do it. And that way you put, the onus on your client, having them be involved in their own transaction. That way they take on some responsibility as well, and you're protected with a good defense should anything come up. Next slide. So a couple of these slides are going to be a repeat for some of you, and I apologize, but when we talk about the standard of care, that's your level of service in a case. And so if you're operating at the standard of care, meaning that you're following all the bare minimum DRE required rules, you can usually win a lawsuit. If you're not complying with all of those rules, it can be very hard to win a lawsuit. But if you're going above and beyond and doing those additional emails and things that I said, you're going to have the best chance to win a lawsuit. So it's really important to kind of not only make sure you're complying with all the DRE rules and regulations, but kind of doing those extra communication steps, because those are the people who I see that get out of lawsuits on motions or a very cheap settlement. Next slide. I think we got a chat. Oh, you're on pause, or you're on mute, sorry.
Sorry, I said it's not related to the slide, so we can keep
Oh,
going.
okay, good. I just wanted to make sure somebody wasn't there like, wait, hey. All right, so to kind of give you an idea of what disclosure requirements are like here in California, which is our second topic today, I wanted to kind of go over what the actual civil codes say and what the jury instructions say, because the jury instructions are basically, they go back to the jury, those 12 strangers, and those are their instructions. They have to determine the case within those parameters. So they're using those as basically their guideline posts to figure out who's liable. So being familiar with it is really important. I'm sure this is a very basic one that most of you guys know, but Civil Code 2079 says a real estate agent or broker has a duty to conduct a reasonably competent and diligent visual inspection of the property offered for sale and to disclose that to that prospective purchaser all facts materially affecting the value or desirability of the property. This is really broad. And so this comes up a lot, and we'll get to this in a little bit, of what happens when something's not visual in nature. Say it's a neighborhood nuisance. I recently had a real estate agent call me and say, I just heard from the neighbors that our house is the local haunted house that I have listed. Do I have to disclose that? We get into weird places with this, but because this is so broad, the standard is essentially put yourself in the buyer's shoes, and would you want to know about it, or would a reasonable person want to know about it? That can be a lot of different things. As far as the visual inspection goes, I'm sure you guys learned last week when you guys did your home inspection, it's visual only. So keep in mind, you don't have to hop on roofs, you don't have to go under homes, you don't have to know what's going on inside the walls. It's just what you can see. I always tell my agents, one of the worst things I ever see in a lawsuit is what we call the clean AVIDs, where I get an AVID that's either completely blank and just signed, or it says next to every room, looks great. Or even worse, where somebody uses it as marking materials and basically explains all the upgrades in every room. Look, no house is perfect. Every room you're going to walk into, you can find a scratch in the wall, you can find a ding in the door, you can find something. I always urge my clients, make sure that thing is filled out as much as possible. You can absolutely find something in each room to put down. That again will also protect you guys. And so it's something to consider. If you can go to the next one. So this one is, Casey is the California jury instructions. And so this is one of the instructions that would go to a jury, and it's the duty of disclosure by a real estate broker to client. And so as a fiduciary, a real estate broker must disclose to his or her client all material information that the broker knows or could reasonably obtain regarding the property relating to the transaction. Reasonably obtained, again, is vague. Usually under the law, this doesn't require you to go down to the city and pull permits to research the tax history of a property, the zoning history. Those things are excluded. But if you can call up the other agent and say, hey, we need the prior disclosures from the sale, this was a flip, that's something you can probably reasonably get. And so those are the kind of items that is contemplated here. So if you can reasonably call up the other side or find something within your file or has been provided to you, you have a duty to disclose that and provide that. If you can get that information easily from the seller, you have a duty to go, call their agent and figure out if you can get that. And again, this is so subjective. So you see down here, this is another little blurb from this jury instruction. The facts that a broker must learn and the advice and counsel required of the broker depend upon the facts of the transaction, the knowledge and experience of the client, the questions asked by the client, the nature of the property, and the terms of the sale. And then here's that standard I discussed earlier. The broker must place himself or herself in the position of the client and consider the type of information required for the client to make a well-informed decision. Every transaction is different. The way you're going to advise a brand new first-time home buyer is going to be radically different from your flipper or your investor who knows quite a lot about a property, or even your contractor who's on his third home purchase. You got to kind of figure out their knowledge and sophistication and get yourself to their level in terms of what you're explaining to them. If If the property in itself is unique or in a unique area, that's going to affect how you advise your client as well. You might have to advise them to get more home inspections, to do further research. Same with the terms of the sale. And this one's kind of vague, but I always warn my clients, if you're dealing with a transaction where there's going to be a carryback note, meaning that the seller's carrying back paper and essentially funding a portion of the buyer's purchase, if you represent that seller, this is kind of what we're talking about, like terms of sale that might be unique. Have them go seek advice of counsel, make sure that's what they want to do, and put that in writing. Again, I know the card forms say go talk to an attorney in like 7 different places, but clients aren't reading that. So I always tell people, if there's a unique term of the sale itself, go double check with an attorney, make sure that's one that works. There might be tax issues. 2, what are the risks? And 3, are there any other legal documents that need to be associated with this then? Because remember, you're not an attorney. You can't give legal advice. If you do, then you're taking on that responsibility. So we want to avoid that. There's the experts that can do that. So always make sure you allow them the opportunity to go seek advice of counsel if there is a unique term in the transaction itself. Next slide.
I have a question.
Yes.
So for the slide that we just went over, if there's a property like on the MLS system and it has like attached documents, whether it be like a house or a land lot, just something that the client's interested in, as agents, do we send those supporting documents to the client? That way they can always review that information and be like, okay, yeah, like this is a home that I would still want to see, even though like there's this information attached to it. Or is like that, I guess, information supposed to be more confidential or just for the real estate agent, or how does?
So I think anything attached to the MLS listing regarding the property is, you are obligated to provide your client, in my opinion, for them to consider the property. And so how I would convey it is say, here, this information was attached to the MLS listing.
Mm-hmm.
So that way you're verifying where it came from, and then say, I have not researched these items and I don't know the accuracy of them at this time, but I wanted you to be aware of them. It's kind of a real simple way, but that way you cover yourself, you're letting them know where it came from, and the fact that you don't know necessarily if it's absolutely true, and you're covering your butt as well.
Mm-hmm.
But yeah, I would provide, because the disclosure requirements in California are so broad, I would provide everything you see. But
Okay.
always verify where it came from, and you don't know anything else about it other than you got it, basically.
Okay. Thank you.
Yeah, no worries. So yeah, this is another, I'm not going to go over this in detail, but this is another example of a jury instruction. So this one's for failure of a seller's real estate broker to conduct an inspection. Again, you see that the standard, it's a reasonably competent and diligent visual inspection of the property. And you've got to disclose all facts that materially affect the value or desirability of the property that the investigation revealed or should have revealed. And again, this can be issues with the actual home. Maybe you walked in and the roof is leaking, or this can be issues with the neighborhood, such as nuisances. Maybe you come and inspect the home and there is a neighbor yelling that she's going to cut down a tree on the property or something crazy. Kind of got to disclose that, because that might be a fight this new owner might have. And so keep in mind, it's not just your visual stuff within the home. That's your requirement to go inspect and put down on the AVID, but even the non-visual stuff, if you see it, you got to put it on the other section on the AVID as well. And we'll go over that again. Next slide. And so again, this is just another Casey instruction, jury instruction. This is the duty of disclosure. You can see it's the same standard. It's must disclose to the buyer all known facts relating to the desirability. Again, if broker must disclose these facts if he or she knows or should have known. Keep in mind, though, under the code, buyers still have their own duty to investigate separate from the agents. So one of the arguments you see come up a lot, and I make this defense argument for my agents all the time, is something that's open and obvious. Maybe my agent accidentally failed to disclose it. If it's open and obvious, generally under the law, you don't necessarily have to disclose those facts if the buyer already knows or could have learned with diligent attention and observation. And so, you know, a perfect example is, say if you're a real estate agent and you're representing a buyer that's buying a property next to an electrical plant. It's literally right next door. Your buyer comes out and inspects the property multiple times. You don't disclose anywhere on the AVID that this property is next to this electrical plant. Even though, again, you could probably put it under other, and I would suggest that you do, but say you didn't, and that buyer comes back and tries to sue you. Well, that was open and obvious. The buyer should have known that, and that would be your defense. That is a fairly strong defense, but the strongest defense is just to put it in the AVID altogether. That other section on the AVID is highly underutilized, in my opinion. I would put down anything intangible that you see that might be of concern. And we'll get to some examples in a little bit. And again, anything you see, document. Even if you don't understand or know what it is, I sometimes get calls from agents where they're going out to do their AVID and they're walking the property and they just see, you know, pooling, or they see a neighbor starting what looks like major construction. Inform your client of that. Again, that goes under the other. This is what I saw. I visually saw this. I don't know what this means. I've not investigated further, but be aware, you know, it looks like the neighbor's building, you know, a huge compound, or the backside of the property seemed really muddy and wet, and the rest of the property wasn't. I don't know if there's a drainage issue. Buyer to investigate. Document everything, because if those come up later and it's made known that you kind of observed it and you were aware of it and you didn't disclose it, that can really work against you. All right. Let's see. Sherry wants to know, do home inspections, NHD reports count as disclosure if the agent did not disclose those things? Yeah, look, if something's on the natural hazard report or the home inspection report, those count as disclosure, because those are disclosed during the escrow process at the time when the buyers or the sellers, people can potentially back out. So they have an opportunity to walk if all of those. And keep in mind, the home inspection is going to hopefully find more things that obviously are not visual in nature that you would not be able to disclose. And so, yes, the home inspection does cover you to some extent. I always, you know, perfect example is the home leaks. I have a lot of those lately where I have sellers or buyers, you know, have disclosed either they just bought the house and there was a freshly painted ceiling, or there was a stain on the ceiling. They came in with a water meter, saw there was no water, so they painted it over. And then guess what? That started leaking as soon as the person closed escrow. It's like second nature, happens every time. Those cases, when you have a home inspection report where the home inspector has called out those issues and said, go have a roofer come in and, you know, review this and look further to see if there's repairs to be made, and they don't do that, that does protect you. And so, yes, all of these things work in tandem together. Anything the home inspector discloses covers you to some extent, but also you still want to make sure your AVID is completely filled out as much as you can do, if at all possible. That was a good question, Sherry. I appreciate that one. All right, so let's go to the next slide. So, all right, you're in escrow. You represent either the buyer or seller. Doesn't matter for this example. Point is, they're going to go in and you're going to do your AVID. So one of the things you need to do is consider any red flags you see. These are things that might alert you to a problem or a potential problem in a transaction. And again, all you have to do is a reasonably competent visual inspection. And if you can go learn the information, you know, in a reasonable way, meaning contacting the other parties, you have a duty to do that. And so your investigation as to any red flags should really just kind of be your common senses. You know, you're going to investigate, you're going to ask questions, you're going to listen, and you're going to document everything. Next slide. So the number one issues I see pop up a lot. One is uneven floors, especially if you're out in East County, there is a lot of uneven foundations. If you walk into a property and you can feel cracks under your feet, unevenness. I've walked into a lot of properties, I'm sure you guys have as well, where, you know, they've been recently flipped, and I can just feel, I usually wear flats, so I can just feel under my feet that they just slapped on floorboards over a, you know, cracked foundation. If you can feel that with your senses, disclose it, and then let your client know you should investigate this further. This one's intangible, but this comes up a lot. Neighborhood characteristics. If there is a haunted house, apparently, or a murder house or a meth house down the street, you got to disclose that. If you represent a seller, I realize when you tell your seller that, they are going to flip their lid. People don't necessarily want to disclose things they don't have control over. And of course, they're going to have the natural fear of, this is going to affect my bottom line, how much I can get for this property and when I can sell it. I always tell those agents, yes, that is an uncomfortable conversation to have. I'm not going to disagree. But the way to coach it or couch it with your seller is, hey, look, this is what the law says. You know, it's a very broad disclosure requirement. So by disclosing this, you're protecting them as well as yourself. It's not just about you. By disclosing it, just in case, that guts a potential claim from a buyer against that seller. And so you're trying to cover their butts too. And so I always kind of couch it that way with them, like, look, this is what the law is. I can't unfortunately change the law, but by doing this, we protect you from any potential claims, lawsuits, mediations later on, which could be very, very expensive. But neighborhood characteristics, if you see something weird in the neighborhood, the party house, again, this is subjective. So this is pretty broad. I had a case a couple of years back where we had a nuisance lawsuit in Carlsbad where the buyer sued my client, who was the seller, claiming she didn't disclose that there was a house next door where they worked on cars late into the night and liked to smoke weed outside. We had to settle that case. As silly as that case was, that might not bother most people, but that bothered these parties. And so keep in mind, we got to take our ego out of it and not be the gatekeeper of what we think is reasonable. Just if there is a characteristic out there that we think might bother somebody, disclose it.
Melissa has a quick question. She said,
Yes.
would dog barking, noise close to freeway and construction also fall under neighborhood characteristics?
Absolutely. Yes, I would. If there's going to be extreme loud noise, like if you're under a flight path, if there's crazy construction going on, if you're next to a high school that really loves to do band practice literally every single day at a certain time, you want to disclose those things. And keep in mind, most of these things that I'm talking about ultimately don't bother the vast majority of the people. But the problem is, of course, it's Murphy's Law. The one time you don't disclose, that's going to be the person that's bothered by it. I'll give you another example. I bought my own home 2 years ago, and the seller failed to disclose that they used my home for like this B-movie horror film. It's a terrible movie. Never disclosed it during escrow. I found out during escrow. I don't even remember how I found out. It didn't bother me. I actually thought it was great. It's fantastic. I'm a weird kooky person, so it didn't bother me at all. My boss here, when he overheard it, was like, we should send them a demand letter and we should sue him. I'm like, no, to me, it didn't affect the desirability of my home, but it is something they probably should have disclosed, because some people might be bothered in that. There were a lot of fake murders in my house, apparently. That might not be cool with some people, but those are the kind of things where, yeah, 80% of the people aren't going to be bothered by that. But for those who are, and especially dog barking, I hear about the dog barking one a lot. And it's usually when people are running kennels, or if there's a particular dog that's really barking at all hours of the night because they're left outside or what have you. Those are the ones where you especially want to disclose. And again, this goes back to, and I know most of your agents do this because we talked about it last time, but I always tell the clients, drive by the property and kind of hang out at all hours, get familiar with the neighborhood. You want to know early on in advance if there is a party house, if it's constantly loud at night, if there are dog barks at all hours of the night. Put that in writing. We got our home because the buyers. Oh, wow. Yeah, I mean, this is another thing. If this kind of discusses, this touches on something else. If you are aware of a previous lawsuit affecting the property or a claim by a neighbor or somebody. Those are the things you do want to disclose just in case. Again, it might not be an issue at all, but you want to make sure people are aware. I've had the case where there was a dispute with a neighbor over a boundary and it wasn't disclosed. The property sold to the new party. And then that new party got slapped with the boundary lawsuit. And they're like, what is going on? I thought I just bought a house. We were going to be happy. You got to disclose if you learn of those things. You might have a seller who goes out of their way to not disclose these things to you. Those sellers are out there, but that's going back to my email of here are your duties to disclose, giving them that instruction. And if they fail to follow it, then look, it is what it is. You're protecting yourself as well as them. But those are kind of things to consider. Demands to waive all contingencies with offers. I included this because obviously during COVID, this was like suddenly the cool thing to do, and it absolutely horrified me. If you have clients, I think this climate's over, so I think we're done with this. But if you have clients that want to make this kind of offer, you got to put it in writing that you're not recommending this and that they should go seek advice of counsel, because there's legal implications by doing this. Basically, once you waive contingencies, you're really locked in at that point. And so if they don't move forward, they could be sued for specific performance, for money damages, things like that. I absolutely strongly recommend trying to talk clients out of doing that, because by having the contingencies, it's a protection for them. And by waiving that, what happens if they find out, there's severe structural issues with the property and now they're stuck? So just, if they want to move forward, look, great, but just put in writing, look, go seek advice of counsel. I don't really recommend this. There are legal implications that you need to talk about with an attorney. The classic one, fresh paint on one wall. Ask the agent about it if you see it. What's going on? They may just have had a dirty wall and painted it, but more often than not, it's usually because there was a leak, there was a mold, there was something going on. The wall got smashed. Who knows? Unexplained cracking or leaks, if you see them, disclose them. That's if you see them. Again, we're talking just visual. You're not required to open cabinets and look inside things, but if you happen to see like a exposed pipe leaking, disclose that. Disclose that in your AVID and say, hey, look, I don't know the source of the leak. You should go hire a plumber or a contractor to look into this to see if this can be repaired. Do disclose. Uncertain boundaries. Keep in mind, you guys are not surveyors. You're not required, and nor should you try to verify where boundaries are in property at all. Always instruct your clients in writing if there's a concern about a boundary. However, I put in certain boundaries here because every once in a while you'll go to the property, and you guys have seen it, I'm sure, the zigzag fence, where you're like, okay, it's not a straight line. What does that mean? Where is the boundary? What I would do if you see a zigzag fence is under other on my AVID, I would say, hey, buyer, I noticed fence is not in a straight line. Buyer to investigate boundaries. Just put it very simply like that, because that to me, because again, remember the standard is if you knew or should have known about something, and when you see a zigzag, it's like, okay, well, there might be a problem there. So just alert your clients to it. If they choose to not investigate it at that point, that's their choice. But if they do and everything's fine, great. If they do and everything's not fine and there is a boundary issue, it's better that they know now than later. Because then if they know later and this, this might become very expensive for them. And as you guys will hear a little bit later, one of the issues a lot of times when there is a buyer-seller dispute over non-disclosure, even if the agents didn't do anything wrong, you guys are still targets to be sued, because the way both the parties to the transaction and the attorneys look at you guys is they think, hey, you guys have insurance, you guys therefore are pocketing and can contribute towards settlement. So I see a lot of cases where even the most fraught arguments are made towards me that just barely work, trying to keep my client in a case because they want to keep an agent in because they think you guys have money. So just be aware of that. Recent construction, lack of documents, that's something, look, if there was an addition made to a property and you ask that seller's agent, hey, where's the permits, where's the plans? And they're like, we don't have them. Let your client know that and tell them to go and investigate that, because Maybe stuff wasn't permitted. Maybe it's not to code. Don't save that for later. Inaccessible areas. My classic example of this is the garage full of boxes. If you can't get access to an area, note that in the AVID. Say, for example, couldn't inspect the garage. It was full of stuff. Buyer should investigate. You want to do that because I don't know how many cases I've had where you have the classic garage situation. It's full of boxes, and then suddenly close of escrow happens. The boxes are gone. And then we look down and there's a cracked foundation, or we look up and the roof is leaking because, of course, naturally Murphy's Law, it's going to rain the day they close escrow. It always does. Those things you want to make sure, again, you're letting your client know, hey, you can go proactively investigate these. Claims to not have disclosures from recent sale. That's another thing you must disclose to your client. That's always concerning to me. If somebody sold a property in the last 5 years, if we're being honest, they should have their previous disclosures. We've been doing everything via email and DocuSign for quite some time now. So it's easy to get those documents. And especially, as you guys know, you guys have a duty to hold on to transactional documents for 3 years. So especially if you're within that 3-year window, there's no reason that seller can't go and get those documents, even if they don't personally have them. So I would let your client know that they're either saying they don't have them, and then push on that other agent a little bit. Hey, go do your job, get those documents. They're out there usually. Next slide. And these are just other kind of quick examples. Oh, yeah. I want to go over kind of some of the non-visual ones because these are important too. Another thing I started seeing pop up in COVID especially was, who do you represent and who's actually selling the property? When you guys get the preliminary title report, as you guys know, it's not your requirement to go in and interpret anything or advise them as to anything. But if you get a preliminary title report where the first thing on top it says who's on title is a name you've never heard of, disclose that right away. This happened a couple of times during COVID where you had people where, say, mom and dad passed away and they were trying to sell the property on behalf of their parents, but they hadn't gotten approval by the court yet. They were not appointed or had a legal authority to do that. And so those are just quick things you want to notice. If the other party doesn't have permits, plans, or documentation, tell your client, tell them to go investigate that. If you learn about prior disputes with neighbors, you got to disclose that. Again, threat of the lawsuit, got to disclose that. Unusual neighborhood characteristics. And I put down here, what did the agent know and when did they know it? That is kind of the standard rule that attorneys keep in mind when they're investigating these claims, is they're going to try to figure out, one, if you guys knew, when you knew, and what did you do about it? Because that will assess whether or not the agent is liable for non-disclosure as well. Next slide. Just a couple of examples, and we kind of went over these already. Room addition not permitted is another one that comes up. If a former owner applied for a permit and was denied and you become aware of it, make sure your client again is aware of that. That it can mean nothing. It could mean that they just didn't go forward with stuff. It could mean that they built everything anyways with the denied permit and maybe it wasn't to code. Just give your client the opportunity to investigate that. Similarly, if you become aware of repairs completed by an unlicensed contractor, disclose that. More often than not, it's usually just a handyman and it's something that's fine. But look, I've had the case where somebody had an unlicensed contractor come in and build an addition and was not to code at all. The neighborhood drug house, if you're aware of it, you gotta disclose it. Cracked slabs, again, are big. If you become aware of a cracked slab, let them know. And always, again, remember, this is subjective to the buyer. So even if it's stuff that won't necessarily bother you, err on the side of caution and disclose, in my opinion. Next slide. So I'm not going to spend a ton of time on the flip house, but just be aware, if you have a flipped house that you are involved with somehow in the transaction, whether you represent the buyer or the seller, the best practice that you should always have is, if you guys had the prior listing, you guys already have those disclosures, submit those disclosures again and make sure that they're historical in nature, designate them that. Like here, these are the previous disclosures. We're going to send you the current disclosures as well, but here's the previous, so you know, because Have all of those issues been repaired? Were all of those issues remodeled? We don't know, but you're putting the other party on notice. That way they can make that decision for themselves. And keep proof that you submitted those previous disclosures. I would keep that email somewhere. If it's a new listing, however, talk to that seller and figure out where their prior disclosures were. Make sure they're very aware of what they have to disclose and explain that it's to protect them as well. Most flippers at this point get it. They do enough of these transactions that they know, but you'll definitely get the newer flippers who might be a little bit more cavalier about this stuff. And you want to kind of rein them in, because I can't tell you how many flipped houses here in California wind up in lawsuits. I think if you did, and this is just a total speculation, but if you looked at the statistics of, you know, what people sue on, is it new construction, older homes, flipped homes? I feel like flipped homes is a fairly large chunk of that, more than we probably anticipate, just because you guys have seen it. There's not, you know, there's a lot of bad flips out there, unfortunately. Some of them look really nice, but you realize it's all cosmetic in nature and they never fixed actual real issues with the home. So just make sure with flipped houses, again, take your time, make sure all those disclosures are made. Check in with your broker if you have questions on that. Next slide. And we kind of went over this already, but nosy neighbor comes over and says something disparaging about the house. Should you disclose that? Yes. And I'm sorry to say that to you guys, because I know a lot of that, we have so many looky-loos. I mean, I think if I asked you guys right now, everyone would raise their hand when I ask, hey, have you ever had an open house and the neighbors randomly show up? Yeah, they almost always do. And sometimes they do say, you know, disparaging things about the house or the neighborhood. There's been law on this, and yeah, there are cases say, you know, you've got to disclose, and your seller might not necessarily like that. But again, go back to that mantra of, we're protecting you in this circumstance. This is for you. You disclose it in the AVID other section. And you should disclose technically what you've been told by the third parties, how you learn the information, and you haven't investigated it. If you're the listing agent, you must disclose to your own client as well. Again, if this comes up, get your broker in the loop, make sure they're aware, and maybe run the disclosure by them first. You guys can also always call me about that as well, because these are the kind of little issues that pop up where it's like, okay, let's slow down the transaction and let's make sure we do this correctly and document this effectively should there be any issues later. Next slide. And here I just kind of wanted to say, this is more just so you guys know, we get, you know, we run the gamut of allegations against real estate agents, but here's kind of the top things I hear buyers and sellers complain about when they talk about their agent or the other side's agent. You know, I was told not to worry about it, or all houses in this neighborhood have the same issue. That's not going to be expensive to fix. This won't have impact on the value. I trusted him or her to protect me. That's probably the number one I hear. I also hear people complain, you know, they didn't keep track of dates. You know, sometimes if somebody doesn't, you know, remove contingencies by date certain and that seller wanted to back out, that can become an issue later. Underestimating timelines, especially with respect to lending. Just a quick aside here, if you have a transaction that deals with both the purchase and sale of a business and property, make sure you're really checking in and determining when the close of escrow date should be, because the timing is very different on those things. And then next one, they were dual agents and didn't represent my interests. They represented the other side. Next slide. So common errors by agents that I do see that can become issues is not identifying these red flags we've been talking about. Not staying in their lane. Don't agree to go down and pull permits or look for plans or stuff. You're not required to do that. And once you take on those responsibilities, you become liable for the outcome of them. So stay in your lane. Even if you have construction expertise in your background in your past life, don't speculate or give, you know, advice as to those issues. Leave it to the professionals. Verifying information that they receive from a third party. Whenever you get information from a third party, always let them know, hey, I've not verified this. You should go investigate this. And similarly, if an issue pops up, get your broker involved, because that can become an issue later if the broker, one, wasn't involved, and two, your broker's seen everything under the sun at this point. So your broker probably is your best resource in how to handle it. Next slide. I know I'm running out of time. I went a little long, but I just want to be clear, dual agency, it's very popular here in California. Keep in mind, if you guys are doing dual agency, you know, there's increased scrutiny from the courts. So you want to make sure you're really, really communicating, you're effectively documenting everything and doing exactly what you should be doing. Plaintiffs love these lawsuit plaintiff attorneys. They can't get enough of it, because in any other professional field, dual agency such as this usually is allowed. It's an inherent conflict of interest. This is kind of the one area for professionals where we do allow this. And as a result, you have these attorneys that are like hawks that just love these cases, because they know more often than not, they can find something and run with it in them. Next slide. So whenever you're, and this is the same for any transaction, but especially if you're a dual agent, you got to ask yourself kind of the basic questions up front. Who do you represent? What are your duties you owe to each party? Remember, if you're representing a buyer or you're representing a seller, you always owe the duty of honesty to either party, but you owe special duties to your clients. Always ask yourself, have all the disclosures been made? Have I received everything? Did I do my AVID? Is there anything else we're concerned about? Anything else we should ask about? Has your client been advised in writing to investigate, hire an inspector, research further? Again, going back to that communication, those emails are so important. And then have you informed your client what information is not verified in the source of information? Next slide. So kind of, you heard me use the term fiduciary duty. That's the duties you owe to your clients. They're essentially the duty of loyalty, meaning that you're representing them and only them, and you're doing whatever is in their best interest. Care, to do things effectively. Disclosure, and then good faith. You're supposed to require, you know, you're just provide the highest good faith and undivided service and loyalty to each of your clients. Next slide. I'm not going to go into this in detail, but just kind of, you want to know what the codes say on what each type of agent owes and what duties. It's mostly overlapping. The big thing, obviously, with dual agency is you got to disclose everything to everyone, and you can't really negotiate the price, but just kind of be aware of these. And then next slide. So disclosure of material information. These are the two biggest cases in California for real estate agents. If you're really bored one Friday night, they're free on the internet. Woohoo. But if you want to, the Cliff Note version is essentially this. This California federal bank case requires that agents have a duty to learn and disclose facts material to the property's price or desirability, including those facts that might be reasonably discovered by the buyer. That goes back to that standard we talked about earlier. If you can get this information easily, you have to do it, meaning you can get it from the other side. Salahutin is the other case, and this goes back to this verification of accuracy of information transmitted to the buyer, and you got to explain if it's unverified. Next slide. So this is a little blurb from Salahutin. What this case was about, essentially, this was a property up in San Jose. Real estate agent represented a buyer who wanted a property that was at least 1 acre or more, because their goal was to subdivide it so they could build a second home on the lot and have family members live there. And so, unfortunately, this agent told his client, yeah, I saw on the zoning and on the the tax documents from the assessor, it's 1 acre. We're good to go. He didn't verify it. He didn't tell him where they got the information from. Sure enough, close escrow. Buyers then go down to the city to try to, work on subdivision, and they're told it's not 1 acre, it's just shy of 1 acre. And so they can't do what they wanted to do with the property. And so the court, unfortunately found for the buyers in this circumstance. The agent was found liable, and the standard they came up with, this is a real estate broker cannot accept information received from another person, such as the seller and the seller's agent, as being true and transmit it to his or her client without either verifying that the information is accurate or disclosing that the information has not been verified. So again, whenever you get that information, you got to tell them the source. Here's where I got it from. I haven't researched this. I don't know its accuracy. Buyer to investigate. And that circles back to that whole communication. Get the buyer involved. You want to make sure they're all constantly told to investigate. Next slide. So with all this said, I want to kind of just go over to recap my tips for you guys. Again, with your AVID, go through every single room, find stuff to mark down in every single room. Utilize that other section for those intangibles or those things where you're like, I just don't know where to put those. Keep in mind that your duties to disclose continue until the moment that property closes escrow. And so if you figure out something on the last day or informed, you still got to do disclosure. And I would say do an email to the client in writing, verify where you heard the information from and that you haven't investigated. A lot of times agents, once they do their AVID and the disclosures are done, they think they're done with disclosures. Your fiduciary duty to disclose continues until that property transfers over. So keep on that. Always be clear what you will and will not be doing for your client in writing. Again, if they think you're going to go down to the city and investigate the property, let them know that that's not your role, but there's experts that can go do that for them. This one's kind of trivial, but don't comment negatively on a transaction to third parties. Look, if there's a lawsuit later, things that you've said may come out. And so I've had the emails where, you know, I've had agents calling their clients, you know, words in emails to say escrow or another person, and that comes out, and that could really harm things. Don't make post-closing concessions or settlements without talking to your broker first. Again, your duties end the moment this closes escrow, so you don't owe any further duties after that. So your broker may not want to make a concession, one, and two, assuming you do want to make a concession, you want to trade that for a mutual release of all claims. And so talk to your broker, because that might be the time to get, say, me or another attorney involved to make sure we get a release of claims in exchange for whatever the concession is. That's very important. Document your file religiously. Keep all those emails, keep those text messages. Make sure you have everything together and ready to go if anything ever happens. If you get a threat, a complaint, an inquiry or demand, and to me that includes, I want my whole file, check with your broker, make sure they're aware. The reason I say this is, one, you might be able to resolve this quickly and head this off at the pass. But two, for E&O insurance, there's a requirement to notify early, as soon as you guys kind of hear about a potential demand or threat or issue. If you fail to do that on time, you might not get E&O coverage. So there's an insurance implication of this too. So always keep your broker informed. Next slide. Just real quick, buying a home in 2023. I know the market's really shifting right now, but if you represent a buyer, look, no house is perfect. I always warn everyone about that. They're never going to find exactly everything they want in a house. The construction's not going to be perfect, even if it's a new construction. So just kind of, you know, realize that, make sure you manage your client's expectations, rely on, defer to experts. You got home inspectors, you got roofers, you got surveyors, you got appraisers for a reason. Rely on them. Always recommend in writing that the buyer investigate certain things. Don't guess, speculate, or theorize or minimize an issue in any way. I think this is really important. If you go to a property and say you observe pooling in the yard, maybe even your head, if it's like, say it's a property that has septic, you're like, that's a septic issue. You don't know for sure. You're not the expert on that. Don't say that out loud, because you don't want your client to rely on that and then have that be incorrect, because then they're going to look to you and be like, well, you were the expert and I was relying on you as my agent. So don't ever do that. Similarly with minimizing issues. I even had this in my own sale where we had an issue with the pool and my agent was like, that only cost a couple $100 to fix. It didn't cost a couple $100 to fix. So don't speculate or minimize anything like that. Again, always document the source of the information where you learn stuff. And disclose everything, even if you don't know what it means. Like going back to the pooling in the yard, like you don't know what what caused it, but that's, still disclose. It's up for your buyer whether or not they want to go and investigate that further. And then next slide. That's the last slide. Oh, it's 11 o'clock. I almost made it on time. And then lastly, what should a seller's agent do? Again, document any issues in writing and copy to all parties. Consult with your broker if anything comes up. That's definitely a big one. Log your conversations about the red flag. Maybe it'll be confirming emails. It might be contemporaneous notes. You know, maybe if there's a big one where you have a seller that really doesn't want to disclose something, maybe have your broker on the phone. Make sure these things are documented because that will come up later. And don't assume a seller has expertise on an issue. I've had a lot of ones where I've had sellers that are contractors. And so the agents feel comfortable relying on their contractor seller to determine what is or what shouldn't be disclosed. They're not an expert. And they're obviously biased and looking out for their own interests. So be aware of that. Disclose anything at issue in writing. Again, even if disclosures have been made, but something comes up at the 11th hour, disclose it in writing. And then prior disclosures, if you can find them, get them. So those are my slides. And let's see, I got some questions in here. I've got some recording. Somebody was freezing. I hope you're warm now. And then, all right, can a realtor help a buyer purchase a mixed use property consisting of a business in it? Yes, you can. Now, does your broker allow for it? Check with your brokerage first. Some brokerages don't like to do those mixed use transactions, but I do have agents and brokers who do these type of mixed use transactions. I would strongly recommend make sure you have the expertise and experience in whatever you're doing. For example, I have a lot of brokers and agents I work with that do one specific type of issue. Like I know a guy who does gas stations. I know a person who does preschools, things like that. You want to make sure you stay in your lane and something that you are experienced in. But I would really talk to your broker first and make sure that's something you want to do, because there is additional liability there, because you've got to help them along with the business transaction as well, which comes with its own implications and duties. So that's something I would caution you doing. If you're inexperienced in it, I probably wouldn't. But if it's something, say your broker is experienced in and you want to learn, maybe you guys do the transaction together. I don't know, but that is possible. I see that in transactions often. Any other questions? Everyone's quiet.
Okay. Well, if there's no other questions, then I'm going to wrap up. So Melissa,
Right.
thank you so much. That was really,
Yes.
yeah, that was really good and really informative. And you gave a lot of valuable advice. And I've definitely made some of the mistakes on some of my AVIDs that you mentioned. And I think
We
we
all
all
have.
do.
Yeah.
But I think this will be really important for people doing AVIDs moving forward in the future so that you can avoid some of these you know, kind of potholes, so to speak. So yeah, thank you so
Absolutely.
much.
And I'm here, guys. If you guys ever have any questions, like I said, the best thing you can do is ask the question first before you take the action, because you can't put it back in if it winds up being the wrong thing afterwards. You can't take it away.
Mhm.
And so at any time, if there's a question about, oh, how do I disclose this? Oh, this is a serious issue and my seller doesn't want to disclose this. That's when you talk to your broker. You might want to talk to me. You powwow and figure out how to approach this, because once those disclosures are made or not made, it's very hard to fix afterwards. So if you need to slow a transaction down to resolve something, always slow it down. And I know a lot of times, especially sellers don't want to disclose things, or reluctant to provide information, but always couch it as, we're protecting you because you have these duties under the law too. So my goal in representing you is making sure you don't get sued in the future, you know. That's always the way I kind of couch it to them. They still may not be happy, and if that's the case, that's the case, because you're still protecting yourself as well, and that also matters. All right, guys. Well, it was good to see everybody on this semi-rainy day.
Thanks,
Yeah.
Melissa.
Thanks, Melissa.
Thank you, guys.
Cool.
You guys take
Thanks.
care.
Bye.
Bye.